News Troy. I am Mwisi Mudupe. So on this episode, we are looking at introduction to law and legal method. The module introduces students to the concept of law, its role in the society, and the meaning of legal method. It serves as the intellectual foundation for the study of law by answering the very preliminary but yet fundamental questions such as: what is law? Why does law exist? Why does law operate? And how do lawyers and judges think or reason? So let me just take a breath and ask you to become a member of our community if you are not already one, by simply clicking on the subscribe button, and you immediately be subscribed as a member of our community. This will enable you to get our videos as they drop amongst various other community opportunities. So please kindly click on the subscribe button and like our videos, share to your friends and pals that it could also be useful too. Thank you very much. So now back to introduction to law and legal method. Understanding the nature of the law and the method by which the law is identified, interpreted, as well as applied is essential before you engage in other substantive legal subjects such as contract, tort, criminal law, constitutional law, jurisprudence, and so on. Legal method is therefore concerned not with what the law says, but with how the law works. That's why it's called legal method. In other words, it's the method of law. So let's take a look at the meaning and the nature of law. There is actually no definition to end all definitions of law. So there is no universal definition of law. It's for this reason that A.A. Okuniga is credited with the statement: no one, including the lawyer, has ever offered, no one, including the lawyer, is offering, and no one, including the lawyer, will ever be able to offer a definition to end all definitions of law. One good allegory that is used to capture the fact that there is no standard definition of law is the Indonesian allegory of the 5 blind men who went to see the elephant. And in that tale, it is said that when these 5 blind men went to see the elephant, of course, they couldn't see the elephant because they had lost their sight. And for this reason, they relied on their sense of touch to feel what and therefore know what the elephant was like. Unfortunately, none of them touched the whole body of an elephant. So each of them simply described the elephant as akin to that part of the body that they touched. The one that touched the tail of the elephant is said to have said, "Oh, the elephant is very like a rope." The one that touched the stomach of the elephant is said to have said, "Oh, the elephant is very like a wall." The one that touched the leg of the elephant is said to have described the elephant as being very like a tree. The one that touched the tusk of the elephant is said to have said the elephant is very like a spear. And the one that touched the trunk of the elephant is said to have described the elephant as being very like a snake. So now, all of these men were right by way of that which they touched of the elephant, but overall they were wrong. So usually I normally add that assuming there was a 6th blind man who never went to see the elephant and was at home, depending on the narration of his friends, his 5 friends who went to see the elephant, he would be the most confused man on earth. Why would he be the most confused man on earth? How will this unfortunate man be able to reconcile something that looks like a wall, at the same time looks like a snake, at the same time looks as a rope? A snake and a rope are even similar, so you can reconcile that. But the thing is still very like a tree, the thing is very like a spear. It's a terrible situation to be able to reconcile all this. And if you try to engage your imagery to reconcile all of this, you will know that the man would have been in a terrible situation. And I like to tell you, of course, that each of those blind men must have been resolute in what they felt, because that's what they felt. But that allegory is simply telling us that the law is simply what the law is to us, the how we have interacted with the law. Each aspect of the law we touch will be what the law is to us. And that aspect of the law we have not touched will not know that the law is also this way. So there is an understanding of a law that a judge has. There is an understanding of the law that the society has. There's an understanding of the law that a counsel that is representing an accused person has. There's an understanding of the law that an aggrieved person who goes to court has. And there's an understanding of the law that an accused person who is standing before the court being accused of having infracted the law, there is an understanding he also has of the law. But so when you have all of this at the back of your mind, you will now be able to appreciate all the definitions that are given by the various scholars who have made an effort at defining the law. The first person we'll be looking at is John Austin, who defined law as a command of the sovereign backed by sanction. Then we'll look at the definition as given by H.L.A. Hart, who described the law as a system of primary and secondary rules. Then we'll look at that given by Sir John Salmond, who defined the law as the body of principles recognized and applied by the state in the administration of justice. Now, from these definitions and a plethora of other definitions, some derived even from case law. Now, case law is law made from cases. So, the law from all of this can be understood to be: 1, a set of rules; 2, that are recognized by the state; 3, that are enforced through institution; and 4, that are intended to regulate human conduct. In the Nigerian context, law derives its statutory authority from the constitution, legislation, judicial decision, and recognized customary norms. Let's take a look at the essential characteristics of the law. Law possesses certain defining features. The first is that law is normative in nature. What do we mean by law is normative in nature? It's normative in nature in that it prescribes the standard of behavior. It prescribes what a norm should be. That's why it's normative. It forms norms. It forms behavior. Law is also institutional in that it is enforced by recognized institutions. These are courts and tribunals. Law also has an element of coercion. It is coercive. It's coercive because compliance may be compelled through sanctions. Again, law is general and impersonal. It applies to all classes of persons, not to particular individuals. It applies to all. And finally, law is also dynamic in character in that it evolves with societal needs. It's not static, it grows. It grows with the people, sometimes dies with the people, and at other times even outlives the people. And we'll look at functions and the purposes of law in the society. Law performs several critical functions in any organized society. These include: 1. Maintenance of order. Law regulates conduct and prevents chaos by prescribing behavior that is acceptable. Law is also useful in terms of resolution of conflict. As people interact one with another, even family members, sometimes even twins, do have disputes, do have points at which they will have a misunderstanding. The law aids in the resolution of disputes in a way that does not allow individuals to resort to chaos, to self-help, or even to violence. And this it does by the avenue of courts and tribunals. This provides structured mechanism for settling disputes peacefully. There is also alternative dispute resolution, popularly called ADR, which is alternative to litigation, if you don't want to resort to litigation as a way of dispute resolution. Law also protects rights. Law safeguards fundamental rights and freedoms of individuals. Law also promotes justice through fairness, equality before the law, and due process. And finally, law is useful in social control and change. Law reflects social values and can also be used as an instrument of reform, e.g. human rights legislations. We look at law and related concepts, other concepts that are related to law. This will aid us to understand law properly, in that it will help one to be able to distinguish law from other social control systems which may look like law but are not akin to law. The first we'll be looking at is law and morality. So morality is concerned with ethical standards of right and wrong, whereas law is concerned with enforceable rules recognized by the state. Not all immoral acts are illegal, and not all illegal acts are immoral. So example, lying may be immoral but not necessarily illegal, even though in some contexts it's illegal, like when you are lying under oath. So law and custom. Custom consists of long established social practices. Custom becomes law only when recognized by courts or by legislation. In Nigeria, for instance, customary law is enforceable only if it satisfies the validity test, e.g. not repugnant to natural justice, equity, or good conscience. We will now also look at the distinction between law and religion. Religious rules govern spiritual and moral conduct. Legal rules govern civil obligations. So, while religious law may be recognized within a legal system, e.g. Islamic law in personal law matters under Sharia courts in Nigeria, it does not make religious practices to generally become akin to law. So we'll now go to examining the meaning of legal method. And in order to do this, we'll first take a look at what legal method means. Legal method refers to the techniques, the processes, and reasoning tools used by lawyers and judges in order to identify the law, interpret legal rules, apply law to facts, as well as resolve legal disputes. So legal method answers the question, how do lawyers think or reason? So we'll now take a look at the scope of legal method. Legal method includes identification of legal sources, case analysis and interpretation, statutory interpretation, legal reasoning and argument, use of precedent, legal research and writing. It is both analytical and practical. What is the importance of studying legal method, and why should you pay attention to studying legal method as a law student? The study of legal method is crucial for several reasons. One, it is foundational for legal education, and that's why in many schools, especially at the university level, you will find that legal method is 100 level, is a first year course. It is at the foundation of your legal education. It equips students with tools needed to understand all other law courses. Now, it also helps in the development of legal reasoning. Students learn to reason logically, critically, and persuasively with legal method. Well, it's here that you also engage practical legal skills, because this course introduces skills such used in legal practice, and they include things like case briefing, statutory interpretation, research, as well as argument. Now, legal method also helps in understanding the nature of law. So students appreciate law as a dynamic system shaped by institutions and reasoning, not merely rules. Now, let's examine law as a system. Law operates as a system, and this is because it consists of rules, consists of institutions such as courts and the legislature, consists of procedures, and also consists of enforcement mechanism. This system ensures coherence, predictability, and authority in legal decision making. By way of conclusion, this introductory module establishes the conceptual foundation of legal method. Students should now understand what law is, how it differs from other social norms, and why legal method is central to legal education and practice. The remaining modules, which you will find in all subsequent episodes that will be taken, we now build on this foundation by examining sources of law, judicial precedent, statutory interpretation, as well as legal reasoning in detail. Thank you so much. I really hope that at the end of this module you have been able to define and explain the essential characteristics of law. I hope that you can distinguish from other law from other social mechanisms. I really hope that you can explain the purpose and the function of law. I really hope that you can understand the meaning and scope of legal method, and that you appreciate the role of legal method in legal education. If you have enjoyed this lecture and you can do any of these things, I'd like you to drop what legal method means to you and why you find the study of legal method very important in the comment section. Till next time, I remain Nwesi Modupe. If you have enjoyed this video, kindly like it, share it, and give us a comment in the comment section. While not forgetting, very important,